Welcome to Sovereign Judgment. Today's story is about an HOA board that believed a dock could be taken by vote, stamped by letterhead, and handed to people who had never paid $1 toward it. They had meeting minutes, a laminated map, and a president who spoke as if the shoreline belonged to her. I had the deed under the water. Before we begin, tell me where you're watching from. I always like knowing how far these stories travel. Here's what happened. The first sound was the hollow knock of aluminum pontoons against the dock pilings, followed by the sharp metallic click of a bolt cutter being set down on wet cedar. It was 7:18 on a Thursday morning in late September, and the fog over Sparrow Lake had not lifted yet. The water was flat enough to reflect every warning sign I had installed 3 days earlier. 6 men in work vests stood on my dock, with cordless impact drivers, orange cones, and a folded copy of a board resolution sealed inside a plastic sleeve. Behind them, on the gravel access road, the HOA president watched with her arms folded beneath a cream-colored raincoat that looked too expensive for the mud she was standing in. 2 sheriff's deputies stood beside her. A county surveyor stood beside me. And in the middle of the dock, taped to the handrail, was the notice the board had voted on 2 nights earlier. Community dock reclamation. That was the phrase they used. Not trespass, not seizure, not theft. Reclamation. It is strange how people choose softer words when they know the hard ones might expose them. The contractor closest to the water pointed at the laminated sign I had bolted to the end post. Private lakebed. No commercial work. No alteration without written permission of owner. He looked back at the HOA president, then at the deputies, then at the surveyor holding the certified plat map. Nobody moved for several seconds. The fog thinned just enough for the brass caps of the old boundary markers to glint at the shoreline. That was the moment their whole plan stopped being a neighborhood dispute and became a matter of recorded ownership, criminal trespass, insurance fraud, and a board resolution written by people who had never checked what they were standing on. To understand how an HOA board ended up trying to seize a dock from a man who owned the lakebed beneath it, you have to go back to the spring before the first letter arrived. My name is Daniel Mercer. At the time this happened, I was 52 years old, a licensed geodetic engineer, and the owner of a small boundary consulting firm in Redfern County. Most of my work involved old land grants, shoreline parcels, riparian disputes, easements, and the kind of property descriptions that make ordinary people's eyes blur after 3 sentences. I spent 28 years reading deeds that began with phrases like, beginning at an iron pin found at the northerly corner of the mill tract, and ended with 5 generations of neighbors arguing over 6 feet of gravel. I was good at quiet problems. That mattered. My family's place sat on the west side of Sparrow Lake, a private, 64-acre body of water tucked behind a ridge of pine, red maple, and shale. The house was simple: cedar siding, green metal roof, stone chimney, and a screened porch that faced east, so the sunrise came straight over the water. My grandfather, Elias Mercer, bought the original land in 1968, back when the road was still dirt and the nearest grocery store was 31 minutes away if the bridge over Mill Creek had not washed out. He was not wealthy. He was a survey chainman first, then a county road inspector, then a man who repaired boat engines behind his garage when money was tight. But he understood land. He understood paper. And when the timber company sold off Sparrow Lake and the surrounding basin, he bought not just the upland parcel where the cabin sat, but the submerged lakebed beneath the western half of the water. That detail had sounded ornamental to everyone else in the family. To him, it was the point. He used to say water is not just scenery, it sits on something. The deed was recorded on April 14, 1968, in Book 219, page 447, of the Redfern County Land Records. It described 11.8 acres of upland and 31.6 acres of submerged bottomland, extending from the west shoreline to a meets and bounds line near the center of the lake. The old dock was built 2 years later, in 1970, by my grandfather and my father, with untreated oak pilings. They sank by hand from a flat-bottom John boat. By the time I inherited the property from my mother, in 2019, the dock had been rebuilt twice, repaired 6 times, and photographed in almost every family album we had. There was a picture of my father holding me there in a yellow life jacket when I was 3. There was a picture of my mother sitting at the end of it in 1987, barefoot, with a cup of coffee in one hand and the family dog asleep beside her. There was a picture of my daughter, Claire, standing on that dock at age 8, holding a bluegill with the solemn pride of someone who believed she had conquered nature. So when people later called it community infrastructure, I listened carefully, because that dock was not infrastructure. It was where my family had measured time. The neighborhood association did not exist when my grandfather bought the land. That came later. In 1994, a developer named Lakehaven Properties purchased the eastern shoreline and divided it into 32 residential lots. The subdivision was called Briar Cove. The houses were built slowly over the next decade, most of them vacation homes at first. Then the city expanded, remote work arrived, and by 2022, almost every house on the eastern bank had a full-time resident. Briar Cove had an HOA. My property was not part of it. That was clear in my deed, clear in the subdivision plat, clear in the county tax map, and clear in the HOA's own recorded declaration, which listed the affected lots by number and excluded all parcels west of the centerline of Sparrow Lake. For years, that distinction did not matter. The Briar Cove residents used their side of the lake. I used mine. A few neighbors paddled over from time to time. I never objected when a child's kayak drifted near my shoreline or someone waved from a canoe. My grandfather had been formal about boundaries, but never petty about water. Then the board changed. The new HOA president was named Marjorie Vale. Her official title, printed beneath her name on every letter, was President, Briar Cove Homeowners Association Board of Governors. She was in her early 60s, tall, narrow-shouldered, always dressed as if a photographer might arrive unexpectedly, and she wore a silver dragonfly brooch on the left side of every jacket. I noticed it the first time she stepped onto my gravel driveway because the wings caught the sun every time she moved. She arrived on May 11, 2024, at 9:42 in the morning. I know the exact time because my driveway camera recorded the black SUV before the tires crossed the culvert. She did not knock at first. She stood at the edge of my porch and looked past the house toward the lake, as if inspecting a property she already considered mismanaged. A man stood behind her with a tablet tucked under his arm. I later learned he was the HOA secretary, Peter Mallow, a retired insurance broker who took meeting minutes in unnecessarily formal language. When I opened the door, Marjorie smiled the way people smile when they have practiced it in a mirror. "Mr. Mercer," she said, "we've been trying to reach you. You're here now," I said. She introduced herself, then Peter, then handed me a white envelope printed with the Briar Cove logo, a blue heron standing in reeds. Inside was a 3-page notice. It informed me that the Briar Cove HOA had received multiple resident concerns regarding unsafe and exclusionary use of the Western Dock facility. It claimed the dock had historically served as a shared amenity for the broader Sparrow Lake community. It cited Lake Access Harmony guidelines, a document I had never seen, and requested that I turn over access keys, remove my private signage, and submit the dock for inspection by the HOA's preferred contractor within 10 business days. At the bottom, in bold type, was the sentence that made me look up. Failure to cooperate may result in board action to classify the dock as a community lake asset, subject to association control. I read the sentence twice. Marjorie watched me, still smiling. "Do you have a question?" she asked. "Yes," I said. "What parcel number do you believe this dock is attached to?" Her smile paused. Peter tapped the tablet with one finger. "It's shown on the lake amenity map." "That isn't what I asked." Marjorie tilted her head slightly. "Mr. Mercer, I don't think this needs to become adversarial. The lake has always been enjoyed by the community. I asked for a parcel number." She looked past me again, toward the dock. The water was bright behind her, and the porch smelled faintly of pine pollen and coffee. "The board has reviewed the situation," she said. That was not an answer. I folded the notice back into its envelope. "I'll review your letter," I said. "We'll expect cooperation by the 25th. "I heard you." She seemed disappointed that I had not argued. People like Marjorie often mistake silence for uncertainty. In my line of work, silence usually means someone has just handed you the first exhibit. After they left, I stood on the porch until their SUV turned onto Cove Road. Then I walked down to the dock. The boards were still damp from the night before. A pair of mallards moved away from the cattails near the old stone outflow. The waterline was low enough that I could see the first row of riprap my father had placed by hand in 1982, after a storm cut into the bank. I did not feel angry yet. I felt something more useful. I felt curious. That afternoon, I took the HOA letter to my office and opened the Redfern County Land Records portal. The county had digitized most deeds after 1985, but older documents were scanned from microfilm, and the indexing was unreliable. I already had certified copies of my family deeds in a fireproof cabinet, but I never begin a property dispute with what I think I know. I begin with the public record as it exists on the day of the conflict. At 2:13 p.m., I searched parcel 14-07221-0003, my upland tract. Then I pulled the scanned tax map overlay. Then I pulled the subdivision plat for Briar Cove, recorded on August 3, 1994, in Plat Cabinet C, slide 118. The plat showed lots 1 through 32, on the eastern side, a private road system, a small boat launch labeled Common Area A, and the eastern recreational shoreline. It did not show my dock. It did not show my shoreline. It did not show any HOA interest west of the centerline boundary. Next, I searched for Lake Access Harmony Guidelines. Nothing in county records. Nothing in the state HOA registry. Nothing in the Briar Cove Declaration. Nothing in the amendments. I searched the Secretary of State's business database for Briar Cove Homeowners Association. The entity existed, but its registered agent had not been updated since 2017. The association's annual reports for 2021 and 2022 were late, though later reinstated. That was sloppy, not fatal. Then I pulled the recorded covenants. The governing declaration was recorded in Book 881, page 92. Section 2.4 defined common area as those parcels expressly conveyed to the association by deed and identified on the recorded final plat. Section 7.2 gave the board authority to regulate association common areas. Section 11.8 prohibited the board from asserting authority over non-member property unless granted by written easement, license, or recorded agreement. That last section mattered. I printed it. Then I searched the county grantor-grantee index for any easement from Mercer to Briar Cove, Lake Haven Properties, or any successor association. There was none. I searched by parcel. None. I searched by my grandfather's name, my father's name, my mother's name, and mine. Nothing. At 4:06 p.m., I opened the archived survey from 1968, which the county had scanned poorly. The Lakebed parcel description was faint but readable. It referenced 3 submerged monuments that had been set by brass-capped iron rods driven into the lake bottom along the western basin line. Most people would have ignored that. I did not. My grandfather had helped set those rods. His initials, E.M., appeared in pencil on the field note margin. I sat there for a moment longer than necessary. Then I called the Redfern County Clerk's office and asked for certified copies of the 1968 deed, the 1994 Briar Cove plat, and the HOA declaration. The clerk, a woman named Sandra Keene, knew me from years of boundary filings. "Another shoreline fight?" she asked. "Possibly. Do you need rush certification?" "Yes." "How many copies?" "3 of each." There was a pause. "That kind of fight," she said. "That kind." The next morning, I drove to the courthouse and retrieved the documents in a manila envelope thick enough to bow at the clasp. The paper had that faint, warm smell of toner and old storage rooms. I put the envelope in the passenger seat and drove home without turning on the radio. I did not call Marjorie. I did not post on the neighborhood forum. I did not ask the HOA to explain itself again. There are disputes where the first person to speak loses useful information. This was one of them. On May 21st, 4 days before the deadline in Marjorie's letter, the escalation began. A notice appeared on my dock post at 6:32 in the morning. My camera captured Peter Mallow walking down the shoreline path in rubber boots, carrying a staple gun, and wearing a Briar Cove windbreaker. He did not approach the house. He stapled a laminated sheet to the cedar post beside my private property sign, took a picture with his phone, and walked away. The notice read, Briar Cove HOA safety inspection pending. Do not alter or remove community access structure. I photographed it in place, removed it carefully, put it in a plastic evidence sleeve, and wrote the time on a yellow label. At 8:17, I emailed the board a short response. Ms. Vale, your notice was placed on private property without permission. Please provide any recorded deed, easement, license, agreement, or court order authorizing Briar Cove HOA access to parcel 14-07-221-003, or the adjoining submerged lakebed parcel, recorded in Book 219, page 447. Until such documentation is provided, no person acting on behalf of Briar Cove HOA has permission to enter, inspect, modify, mark, or use my dock, shoreline, or lakebed. Daniel Mercer. I sent it by email and certified mail. Marjorie replied 6 hours later. Her response was 17 paragraphs long. She wrote that my adversarial posture was disappointing. She wrote that Sparrow Lake had always functioned as a shared neighborhood ecosystem. She wrote that the dock had become an inequitable private obstruction. She did not provide a deed, easement, license, agreement, or court order. She did copy the association's general counsel. His name was listed as Calvin B. Rusk, Esq. That name bothered me. I searched the state bar directory. Calvin Rusk had been admitted in 1988, suspended in 2020 for failure to comply with continuing legal education requirements, reinstated in 2021, then administratively suspended again. As of May 21, 2024, his license was not active. I printed that too. 2 days later, Briar Cove sent me an assessment for lake amenity noncompliance in the amount of $1,750. The invoice stated that unpaid balances would accrue 12% interest and may be secured by lien against benefiting lake property. I was not a member of the association. They had no assessment authority over my land. I placed the invoice in the evidence binder behind tab 4. On May 27th, Marjorie posted on the Briar Cove Residents Forum, a private social media group that several of my neighbors forwarded to me within minutes. Her post included a photo of my dock taken from the water. The caption read, "For too long, one non-participating owner has blocked safe and fair use of a lake structure historically maintained for everyone's benefit. The board is taking lawful steps to return this amenity to the community." There were 73 comments by noon. Some residents objected. Most did not know the history. A few accused me of hoarding access. One man named Trevor Dane wrote, "Cut the chain and be done with it." Marjorie liked that comment. That mattered later. I saved screenshots with timestamps, usernames, and visible URLs. I exported the page to PDF. I asked the neighbors who had access to the group, including an older widow named Ruth Bell, not to engage on my behalf. Ruth lived in Lot 12 and had been fighting the same board over an improper drainage fee for 2 years. She had a calm voice, a bad knee, and a sharper memory than anyone on the board understood. "Daniel," she said when she called that evening, "they did this with the boat launch too. They called it safety, then charged us for work nobody approved. Do you still have the letters?" "I have every one." "Good," I said. "Keep them." On June 3rd, I received a letter from Calvin Rusk on Cream Stationery. The letterhead said, "Rusk Legal Group," though the state business registry showed the entity had been dissolved for failure to file annual reports in 2022. The letter demanded that I cease interference with association rights, remove private signs, and provide the HOA's contractor access within 7 days. It referenced customary lake access doctrine, which was not a doctrine recognized in our state for private man-made lakes. It also claimed that the association was prepared to file an emergency petition for injunctive relief. The letter ended with a sentence I underlined in pencil. "The board has voted to pursue all remedies necessary to reclaim the dock." There it was again. Reclaim. A word that sounded lawful if nobody asked what had been lost. I called my attorney that afternoon. Her name was Evelyn Hart, and she had practiced property and HOA law in Redfern County for 34 years. She wore plain black reading glasses, kept handwritten notes on yellow legal pads, and had once won a boundary case because she noticed a deed said white oak stump instead of white oak tree. I brought her the binder. She did not rush. She read the HOA letter. She read my deed. She read the covenants. She read Calvin Rusk's letter twice. Then she removed her glasses and set them on top of the paper. "Do they know you own the Lakebed?" she asked. I told them the book and page. "That is not the same thing." "No." "Good." She turned to section 11.8 of the declaration. "This is their own document?" "Yes. And it says they cannot assert authority over non-member property without a recorded agreement." "Yes." She looked at the Rusk letter again. "His license is suspended as of this morning." Evelyn made a note. Then I asked her the question that mattered. "If they vote to take control of the dock and send a contractor onto it, what can we do?" She leaned back in her chair. "If your title is as clean as it appears, and if the dock pilings are embedded in your submerged parcel, they cannot seize it by board vote. They cannot regulate it by covenant. They cannot assess it. They cannot lien it. They cannot authorize contractors to alter it. If they proceed after written notice, they are no longer mistaken. They are acting with knowledge." That answer changed the shape of everything. We spent the next 2 weeks building the foundation. Evelyn ordered a title opinion from Marlowe Title and Abstract. I hired a licensed hydrographic surveyor named Owen Price to locate the submerged boundary rods and map the dock pilings relative to the Lakebed parcel. I also hired a structural engineer, Priya Nand, to inspect the dock and issue a sealed report regarding its condition, load capacity, and ownership-related improvements. Everything was done formally. Owen used side-scan sonar, a GPS receiver corrected through the state real-time network, and a small dive team to confirm the old brass-capped rods. On June 18th, he called me from the water. "Your grandfather set these well," he said. "They're still there." I stood on the shore holding the phone while wind moved through the cattails. "Can you tie the dock pilings to the submerged parcel?" "Already did," he said. "Every piling lands inside your Lakebed boundary, not close, inside." His final survey showed the dock extending 42.7 feet from my shoreline, with all 12 support pilings located between 9.3 and 38.1 feet inside my recorded submerged parcel. The nearest HOA common area, the eastern boat launch, was 611 feet across open water. Priya's report came back on June 24th. The dock was structurally sound, privately constructed, privately maintained, and not connected to any association utility or access system. She found no evidence of HOA repairs, HOA materials, or shared maintenance. Marlowe Title delivered its opinion on June 27th. It confirmed marketable title in my name, no recorded easements benefiting Briar Cove, and no association interest in either the upland parcel or submerged bottomland. Evelyn then prepared a cease and desist package. It included certified copies of the deeds, the plat, the HOA declaration, the title opinion, the hydrographic survey, the structural report, screenshots of Marjorie's forum post, the unauthorized dock notice, the non-member assessment, the Rusk letter, and the state bar license status. On July 1, we sent it by certified mail, email, and hand delivery to the HOA's registered agent. The package was 19 pages plus exhibits. The final paragraph was plain. Any further attempt by Briar Cove Homeowners Association, its board, contractors, agents, or members, to enter, use, alter, mark, remove, seize, encumber, or otherwise exercise control over Mr. Mercer's dock, shoreline, upland parcel, or submerged lakebed parcel. They received it on July 3rd at 10:12 a.m. Marjorie signed for it herself. At 6:44 that evening, she posted again. "Certain individuals are attempting to intimidate your elected board with technicalities. We will not be bullied out of protecting community access." That was the first time I understood she was not confused. She had been shown the documents. She chose the story anyway. The next month was slow pressure. The board sent 2 more invoices, one for $2,100 and one for $3,400. The descriptions changed from lake amenity non-compliance to shared facility obstruction to legal preparation reimbursement. Each invoice had the association seal at the top. None cited a valid covenant. A lien notice arrived on July 19th. It was unsigned by any licensed attorney and claimed an interest in my property under Article 9.3 of the Briar Cove Declaration. There was no Article 9.3. The declaration went from Article 8 to Article 10, because Article 9 had been reserved in the original draft and never used. That kind of mistake is more than careless. It shows that the person writing the threat had not read the document they were invoking. Evelyn prepared a complaint to the State HOA Oversight Office, a notice to the county recorder warning against acceptance of improper association liens, and a letter to the Sheriff's Civil Division documenting the dispute before anyone tried to create a scene. I installed 3 additional cameras, one facing the dock from the porch, one on a pine tree overlooking the shoreline path, and one small solar unit on the boat shed aimed at the water approach. All footage backed up automatically to cloud storage. I placed 3 lawful signs along the dock access route, each citing the parcel numbers and the no entry notice. I did not block any public road because there was no public road to block. I did not interfere with the eastern boat launch. I did not confront anyone. I also filed a shoreline activity notice with the Redfern County Environmental Office, not because I planned to change anything yet, but because I wanted the county file to show that I was maintaining the dock, not abandoning it. On August 6th, Ruth Bell brought me a folder. We sat at my kitchen table while rain tapped softly against the porch screens. Inside were 4 years of HOA notices, special assessments, meeting minutes, and contractor invoices. The board had charged Briar Cove residents $38,750 in lake access improvement fees between 2021 and 2024. Several invoices referenced West Dock Planning, Community Dock Legal Review, and Shared Shoreline Initiative. None of that money had gone to my dock. None of those residents had been told the HOA did not own it. People paid for this? I asked. Ruth nodded. My share was $900. I copied every page and gave the originals back. The dispute had just widened. Evelyn brought in a forensic accountant named Samuel Voss. Within 10 days, he traced the lake access fees through the HOA bank summaries Ruth had saved from annual budget packets. The money had been moved into a capital improvement reserve, then partially paid to a company called Cove Compliance Consulting. Cove Compliance was registered to Peter Mallow's daughter. That did not prove fraud by itself, but it explained the confidence. On August 22nd, Evelyn sent a records demand to the HOA under the State Association statute. She requested board minutes, contracts, invoices, payment records, legal opinions, and communications related to the dock, the lake access fees, Cove Compliance Consulting, and any planned action against my property. The HOA had 10 business days to respond. They provided 12 pages. Ruth had already given us 96. On September 9th, one of the residents forwarded me a notice for a special board meeting. The agenda included one line item: vote on reclamation of Western Dock Facility and authorization of contractor access. The meeting was scheduled for September 17th at 6:30 p.m. in the Briar Cove Clubhouse. Evelyn and I attended. We did not sit in the front. We sat in the 3rd row, beside Ruth Bell and a man named Alan Ree, who owned Lot 21 and had paid 2 special assessments for lake access improvements that had never materialized. The clubhouse smelled like floor wax and burnt coffee. Folding chairs scraped against tile. A framed aerial photo of Sparrow Lake hung behind the board table, and someone had marked the western dock with a red circle. Marjorie called the meeting to order wearing a navy blazer and the same silver dragonfly brooch. She spoke for 18 minutes. She said the board had been patient. She said one owner had obstructed the community's historical rights. She said the dock was a safety issue. She said the board had consulted counsel. She did not say counsel was suspended. She did not mention my deed. She did not mention the lakebed. She did not mention the cease and desist package she had signed for. Then she introduced Resolution 24-17. Peter read it aloud. The resolution declared that the Western Dock serves and has historically served as a community lake access facility, authorized the HOA to take possession for inspection, repair, and equitable scheduling, and empowered the board to retain contractors to remove locks, signs, barriers, or other impediments to community use. When Peter finished, Marjorie asked for discussion. Evelyn stood. My name is Evelyn Hart. I represent Daniel Mercer. Before this board votes, I am again placing you on notice that the dock and the submerged lakebed beneath it are privately owned by Mr. Mercer and are not subject to association control. Each board member has received documentation of this fact. Proceeding after notice may expose the association and individual directors to liability. Marjorie kept her eyes on the room, not on Evelyn. Your objection is noted, she said. Evelyn held up a copy of the title opinion. Will the board identify any recorded easement, deed, license, or court order authorizing the action proposed? Marjorie's mouth tightened. The board rejects the premise of your question. That sentence became important. The resolution passed 4-1. Only one board member, a retired teacher named Leonard Pike, voted no. I wrote down the vote count. Marjorie looked directly at me for the first time that evening. Mr. Mercer, she said, we hope you will not make this more difficult than it needs to be. I won't, I said. And I meant it. They had created the record themselves. 2 days later, an email from Peter Mallow went out to all residents announcing that professional access restoration would begin on September 26 at 7 a.m. It named the contractor Harrow & Sons Marine Works. It stated that the board had voted to reclaim the dock. It said residents should expect a new equitable scheduling system by October 1. I forwarded the email to Evelyn. Then I made the final preparations. Evelyn filed a verified complaint in Redfern County Superior Court, seeking declaratory judgment, injunctive relief, damages for slander of title, and statutory penalties for improper HOA assessments. She also filed an emergency notice with the court, attaching the contractor email. But court calendars move at their own pace. The judge scheduled a hearing for October 4th. That meant the contractor date would arrive first. So we took the steps the law allowed before the hearing. I sent Harrow & Sons a complete notice package by email and certified mail. It included the survey, title opinion, no trespass notice, and warning that any alteration of the dock would be unauthorized. The owner, Benjamin Harrow, responded within 3 hours. Mr. Mercer, we were not provided this information by Briar Cove HOA. We will review and pause work pending clarification. That should have ended it. It did not. On September 24th, Marjorie sent Harrow & Sons a signed indemnity letter on HOA letterhead. I received it later through discovery, but I knew something had changed when Benjamin Harrow called me the next day. She says the association accepts responsibility, he said. For trespass? For access restoration. Did she provide a court order? No. Did she provide a recorded easement? No. Then you have my position in writing. There was a long pause. I'm not sending my crew, he said. That was the responsible decision. Marjorie found another contractor. A smaller outfit called Lakefront Labor Services agreed to appear on September 26th. Their owner, a man named Colin Briggs, never contacted me, never requested documents, and never asked why the first contractor withdrew. By then, the sheriff's civil division had my file, so did the county surveyor, so did the environmental office, so did the court. I placed one final notice on the dock at 5:40 p.m. on September 25th. It was laminated, bolted to the handrail, and written in plain language. Private property notice. This dock and all supporting pilings are located on privately owned upland and submerged lakebed parcels owned by Daniel Mercer. No person, contractor, HOA representative, board member, resident, or agent may enter, alter, remove, damage, seize, mark, lock, unlock, or otherwise interfere with this structure without written permission of the owner or a valid court order. All access is recorded. I photographed the sign, the bolts, the shoreline, the gate, and the approach path. Then I went inside and made coffee for the next morning. At 6:51 a.m. on September 26th, my driveway camera detected movement. A white utility truck came first, followed by Marjorie's black SUV, Peter Mallow's gray sedan, and 2 other vehicles I did not recognize. The morning was cold enough that breath showed near the water. Mist hovered over the lake in long, pale strips, and the dock boards were dark with dew. I stood on the porch with Evelyn Hart beside me. She had arrived at 6:30, wearing a wool coat and carrying the same leather briefcase she brought to court. You don't speak unless you need to, she said. I know. At 7:04, Colin Briggs and 5 workers walked toward the dock, carrying tools. Marjorie pointed as she spoke, her dragonfly brooch flashing through the fog. I heard her say, "Remove those signs first." Evelyn called the sheriff's civil division. I called Owen Price, the surveyor, who was already parked at the county access pullout with the certified plat copies. Then I walked down the hill. Gravel shifted under my boots. The air smelled like wet leaves and lake mud. A crow called from the pine line. Marjorie saw me and lifted her chin. "Mr. Mercer," she said, "the board has acted. Please do not interfere." "I'm not interfering," I said. "I'm documenting." Colin Briggs stood on the first dock plank, looking less certain now that he was seeing the signs himself. "Are you the owner?" he asked me. "Yes." Marjorie stepped closer. "The association has authorized this work. Do you have a court order?" I asked. She ignored the question. "Colin, proceed." One of the workers set a bolt cutter down on the dock. The sound carried over the water. That was the sound from the beginning. At 7:18, 2 sheriff's deputies arrived. Deputy Marcus Ellery and Deputy Gene Cole had both reviewed the file. They were careful, polite, and did not treat the scene as theater. Owen Price arrived 3 minutes later carrying a rolled survey and a clipboard. He placed the survey on the hood of his truck and pointed to the dock, the shoreline, and the submerged boundary. "All 12 pilings are inside Mercer, submerged parcel 14-07221-004B, he said. "The upland access is parcel 14-07221-003. No association common area touches this structure." Marjorie spoke quickly. "With respect, this is a civil matter. The board has voted." Deputy Ellery interrupted gently. "A board vote does not authorize entry onto property outside the association's jurisdiction." Peter Mallow stepped forward with the laminated resolution. "We have a lawful resolution." Evelyn took one step beside me. "Deputy, that resolution was passed after written notice of ownership and after the board was asked to identify legal authority. They refused. Mr. Mercer does not consent to entry or alteration." Deputy Cole looked at Colin Briggs. "Sir, have you been given permission by the property owner?" Colin looked from Marjorie to me. "I was hired by the HOA. That is not what I asked." His workers had stopped moving. For the first time since I had met her, Marjorie's expression changed. Not fear exactly. Recognition. The kind that arrives when a person realizes procedure has reached a place where confidence no longer functions as evidence. Deputy Ellery gave the instruction plainly. "No work will be performed here today. Everyone not authorized by Mr. Mercer needs to leave the dock and the shoreline." Marjorie's face tightened. "This is outrageous," she said. "We will be filing against him personally." "That is your right," Evelyn said. I said nothing. Colin Briggs ordered his workers off the dock. One picked up the bolt cutter, another gathered the cones. The entire withdrawal took less than 4 minutes. Marjorie remained at the edge of the grass, staring at the private Lakebed sign, as if the words might rearrange themselves. Then Ruth Bell appeared at the road with her phone in her hand. She had recorded the whole thing from the public side of the property line. So had my cameras. So had Peter Mallow, though he did not yet understand that his own recording would later confirm every warning they ignored. The public confrontation came 8 days later. The court hearing was scheduled for October 4th at 9 a.m. in Redfern County Superior Court, Courtroom 3. Judge Alina Cross presided. The courtroom had high windows, wooden benches polished by decades of use, and a clock above the clerk's station that ticked loudly whenever the room went quiet. Briar Cove arrived with Marjorie, Peter, 2 board members, Calvin Rusk, and a new attorney named Joanne Vell, who had clearly been retained too late to control the damage. Evelyn and I sat at the plaintiff's table with 3 binders and a flat folder containing the original certified survey. Ruth Bell sat behind us, with Alan Ree and 11 other Briar Cove residents. Judge Cross began by asking a simple question. "Counsel for the association, what is the recorded basis for your client's claimed authority over Mr. Mercer's dock?" Joanne Vell stood slowly. "Your Honor, the association's position is that the dock has historically functioned as..." The judge raised one hand. "That was not my question. I asked for the recorded basis." Joanne looked down at her notes. "The association is still investigating the chain of use." Evelyn stood. "Your Honor, there is no recorded basis. The association's own declaration prohibits exactly what it attempted." She handed the clerk the certified copy of the HOA declaration, open to section 11.8. Judge Cross read silently. Then Evelyn handed over the board resolution, the meeting transcript, the cease and desist receipt signed by Marjorie, and the video still showing contractors on the dock after the final notice had been posted. Finally, she played the audio from the September 17 meeting. Marjorie's voice filled the courtroom. "The board rejects the premise of your question." That sentence sounded different in court than it had in the clubhouse. In the clubhouse, it had sounded like authority. In court, after the documents had been introduced, it sounded like knowledge. Evelyn paused the recording. "The question they rejected, Your Honor, was whether they had any deed, easement, license, or court order." Judge Cross looked at Marjorie. "You received the title package before this vote?" Marjorie's new attorney touched her arm, but Marjorie answered anyway. "We received a packet, yes. But it was our understanding that long-standing community expectations—" The judge interrupted. "Expectations are not title." The room went very still. Then Evelyn introduced the invoices. The $1,750 non-compliance assessment, the $2,100 shared facility obstruction fee, the $3,400 legal preparation reimbursement, the lien notice citing Article 9.3. Judge Cross examined the declaration. "There is no Article 9.3, she said. "No, Your Honor," Evelyn replied. Joanne Vell closed her eyes briefly. That was when the board began to unravel in public. Evelyn called Ruth Bell as a witness for the limited purpose of authenticating resident assessment notices. Ruth walked to the stand with her cane, placed her hand on the Bible, and spoke in the same quiet voice she used at my kitchen table. She testified that residents had been charged lake access improvement fees for years. She identified the notices. She identified Peter's signature. She identified the budget packet showing payments to Cove Compliance Consulting. Peter shifted in his seat. Judge Cross looked at him over the top of her glasses. "Mr. Mallow, is Cove Compliance Consulting affiliated with your family?" His attorney was not there because he had not expected to need one. Peter said, "My daughter owns a consulting business." The judge wrote something down. The hearing did not decide every issue that day. Courts rarely do. But Judge Cross issued a temporary restraining order from the bench, prohibiting Briar Cove HOA, its directors, contractors, agents, and members from entering, altering, using, assessing, liening, or asserting control over my dock, shoreline, upland parcel, or submerged lakebed. She also ordered the HOA to preserve all records related to lake access fees, contractor payments, legal communications, and board discussions. That preservation order mattered more than anyone realized in the moment, because 3 days later, Peter Mallow deleted the board's shared drive folder labeled Dock Reclamation. He did it at 11:47 p.m. The forensic log recovered by the HOA's cloud provider showed his username, IP address, and device ID. By then, the dispute had moved beyond my dock. The state HOA Oversight Office opened an inquiry. The county recorder rejected the improper lien filing and referred the matter to the Civil Fraud Unit. The state bar opened a complaint regarding Calvin Rusk's unauthorized practice of law. And after Samuel Voss submitted his preliminary accounting report, the Redfern County District Attorney's Office requested the HOA's bank records. I did not celebrate any of that. Formal consequences are not fireworks. They arrive as letters, docket entries, subpoenas, and long silences. But they arrived. On December 12th, Judge Cross issued a declaratory judgment. The order stated that I was the sole owner of the upland parcel, the dock structure, and the submerged lakebed beneath all supporting pilings. It stated that Briar Cove HOA had no deeded, contractual, prescriptive, equitable, or covenant-based right to enter, use, regulate, seize, assess, or encumber the dock. It voided all invoices and purported charges against me. It permanently enjoined the HOA from asserting control over my property. The court awarded $18,600 in attorney's fees related to the emergency injunction, $7,250 in survey and expert costs, and $12,000 in statutory damages for improper non-member assessments and slander of title. The remaining civil claims were reserved pending the outcome of the financial investigation. For the residents, the larger judgment came later. In March 2025, after a special meeting attended by 29 of 32 voting households, the Briar Cove membership removed Marjorie Vale, Peter Mallow, and 2 allied board members by a vote of 24-5. Leonard Pike, the only board member who had voted against Resolution 2417, became interim president. The new board hired an independent accounting firm. Their report found that $52,430 in lake access improvement fees had been collected between 2021 and 2024, with $19,875 paid to Cove Compliance Consulting, without competitive bids, written deliverables, or proper conflict disclosure. Some of the work described in invoices had never been performed. The district attorney charged Peter Mallow with 1 count of falsifying association records and 2 counts of failure to disclose a financial conflict under the state nonprofit governance statute. He later entered a plea agreement requiring restitution of $19,875, 18 months of probation, and a permanent bar from serving on any common interest community board in the state. Marjorie was not charged criminally, but the civil consequences were severe. The court found that she had acted in bad faith after receiving documented notice of ownership. She was held personally liable for $31,400 of the HOA's legal exposure because the association's insurance carrier denied coverage for intentional acts outside board authority. She sold her Briar Cove house the following summer. Calvin Rusk received a public disciplinary order for unauthorized practice of law while administratively suspended. He was fined $6,000 and prohibited from issuing legal correspondence until reinstated. Briar Cove residents received partial refunds from the Lake Access Fund. Ruth Bell's refund was $713.42. Alan Rees was $1,026.80. The amounts were not life-changing, but they mattered because they proved something the old board had worked hard to obscure. The dock had never been theirs. Neither had the money story built around it. The first quiet morning after the final order came in, I walked down to the water alone. It was early April. The air still had winter in it, but the ice had gone from the coves, and the first green shoots were coming up near the stone steps. The dock boards were dry, pale, and silvered at the edges. A light wind moved across Sparrow Lake from east to west, pushing small ripples against the pilings my grandfather had set more than 50 years earlier. I carried the certified judgment in the same manila envelope the clerk had used for the deed copies. For a while, I stood at the end of the dock and looked down. You cannot see ownership through water, not with the eye. The lake gives no visible sign of parcel lines, submerged monuments, book pages, or legal descriptions. It just reflects the sky and lets people believe what they want to believe. That is why paper matters, not because paper is sacred. Because memory is fragile, confidence is loud, and people with titles will sometimes mistake silence for permission. Ruth came by later that afternoon with a thermos of coffee and 2 chipped mugs. We sat on the bench my father had built from leftover cedar and watched a heron move through the reeds on the opposite shore. Feels different now, she said. It is different now. Did you ever think they'd get that far? I looked at the water where the old brass rods sat below the surface, exactly where my grandfather had helped place them. Yes, I said. Once they stopped answering the question, that was the simplest truth of the whole thing. They could have stopped when I asked for a parcel number. They could have stopped when they saw the deed. They could have stopped when Evelyn sent the title package. They could have stopped when the first contractor walked away. They could have stopped when the judge asked for the recorded basis. At every point, they chose the story over the record, and the record waited. There are a few lessons I took from what happened at Sparrow Lake. If someone claims authority over your property, ask for the recorded instrument, not the tradition, not the map they printed themselves, not the board's interpretation. Ask for the deed, easement, license, covenant, or court order that gives them power. When an HOA uses official-looking letters against non-members, preserve everything. Keep the envelope, the invoice, the screenshots, the timestamps, the names, and the exact wording. The paper they send to intimidate you may become the paper that defeats them. Never interrupt your opponent while they are creating evidence. The Briar Cove Board's resolution, meeting audio, false lien notice, and public posts, did more to prove bad faith than anything I could have said in anger. Boundaries are strongest when they are documented before the fight begins. Certified deeds, surveys, title opinions, and lawful notices turned a foggy morning on a dock into a clear legal record no board vote could erase. The dock is still there. The signs are smaller now, The cameras are still up. Ruth still walks over when the weather is good. Children from Briar Cove still paddle near the center line sometimes, and when they wave, I wave back. I never wanted to own the lake in a way that made it feel smaller. I only wanted the people trying to take what was not theirs to learn that water may move, but the land beneath it does not. If you have thoughts on this story, leave them in the comments. Tell me what you would have done when that board resolution appeared. And if you want more calm, documented takedowns like this one, like the video, and subscribe to Sovereign Judgment.